Yeah, ready.
I affirm the resolution applies to children ought to be treated as adults. This doesn't apply that they need to be treated as a stereotypical adult. Judge with the exception of relevant consideration when considering the punishment prosecuted of certain adults, so the same consideration could apply to children. The differences of those rules have to apply in the same way that you do to adults, and thus the adult justice system. Thus, the affirmative advocates using the adult criminal justice system for the prosecution of all vulnerabilities that the negative burden is to defend the juvenile justice system. Additionally, it's defended to prove that treating juveniles in the adult system is preferable to juvenile one, but any other conception renders affirmation nearly impossible. If the negative gets to any distinction in treatment, then enforce the affirmative to prove that there is no relevant distinction between adults and children. This means the only way the affirmative could ever win is to prove a universal negative which involves winning terminal defense on every argument the negative makes. Values must be relevant to the individual. Bernard Regenster writes. It cannot be right to say that an action X is valuable for an agent A when X is alien to anything A cares about or could care about, but the statement X is valuable for A is ambiguous. In the case of motivational journalism, A has a reason to accept the judgment X is valuable. According to motivational journalism, then A cannot have a reason to accept X is valuable unless X serves to further a pre-existing desire of A. This leaves us with internal strategy of re-evaluation. That ethical principle distinctive in the strategy is often called motivational journalism. This is achieved when the rule is not subject to charming alien influences. The internal principle is true because A, for any moral principles, we can ask why it's binding cogently demonstrating there's no necessary influence on my will, and B, even principles that bind implicitly or rationally can be questioned because we can always ask why we have to be rational, care about why we are universalize or care about what is impersonally good. This means the only possible consideration in determining the choice of normative evaluations is the absolute freedom of the will from external influence. Moreover, this means the perception of our conception of permissibility or relevance because there's no way that we can control. There's no way that we can tell the person who's trying to justify to themselves that they ought to act according to a particular moral statement permissible rather than just what's good for themselves. Moreover, any coherent conception of ethics, then value demand a primary concern with the goodness conceived of within human desire and will. Nietzsche writes. This hypothesis about the value, judgment, good service from a psychological contradiction, the utility of an unegoistic action is supposed to be the origin of praise and distortion has allegedly been forgotten. This utility has been everyday experience through the age and has thus always been re-emphasized. It must have been pressed up into the consciousness with ever-increasing clarity. How much more sensible is that theory which proposed the idea of good is essentially the same as humans, as useful so that in judgments about good humans endorse the experiences they have not forgotten concerning the useful, functional, and the harmful useless. Thus, all value judgments that seek normatively guide action is the foundation of the value of actions that are useful to the expansion of the individual's control of themselves. This is furthermore empirically verified by Nietzsche too in his analysis of ethical semantics. The incompetence of historians revealed itself with this process of the origin of good people they proclaim originally placed on egoistic action. Later people felt good as if something were inherently good. The origin of the idea of good has been established in the wrong place. The judgment good and now moved from those who goodness was shown is it was the good people themselves who said their actions that was good in opposition to everything low, common, vulgar. They arrogated themselves the right degree of value, rank setting judgments of value is as inappropriate as possible. The basis of nobility, the dominating feeling of a higher ruling nature, that is the origin of the opposite between good and bad. Given this origin, the word good from the start, no way necessarily tied up to egoistic action. Thus, good actions are those that are consistent with the exception of an age's will for their own personal power. Nietzsche 3 explains why actions taken out of pity function as a moral failure within the individual. Pity is a moral parasite injurious to the health. One does good merely out of pity to oneself that is suffering. Pity does not depend on maximum but emotion. The suffering we see infects us. There is nothing such as egoism which keeps them in its bounds and does not exceed them constantly. The allowable, the morally indifferent egoism which some people speak does not exist at all. One is continually promoting the interests of one ego at the cost of other people. Every instinct sacrifices strength and other instincts into the bargain. In the end we stand, otherwise it would be everything, at the end of everything owing the waste would bring about us. And that which is unegoistic, self-sacrificing and imprudent is nothing in particular. The act counter to our interest against the ego. Thus the standard is avoiding pity. Moreover, pity subverts the will and autonomy of the agent beneath that of the weak and rational, rendering it inconsistent with respect to due power and goodness. Cartwright argues. Our passions are motives of our actions. These drive they often lack direction. Reason is used to direct and satisfy our deepest needs, but a pity can usurp autonomy by placing them under the control of the pity. Pity can be a way through which we see agents gain control of someone suffers. We take possession of him. Those who pity him call for the new possession. Love people suffer because they are unable to receive their own misery. When we vocalize our misery, we seek the assistance of other pitiers. Give this assistance up. Pitiers seek individuals to pity in order to hide feelings of superiority. The pitiers increase their feelings of superiority by doing things they cannot do for themselves, thus conceiving their actions as virtues. Finally, the humiliation brought about by pity punishes the story about the moral status and respect due to agents they become object of inferiority. Cartwright too writes. Pity and compassion suppose the agent of the sufferer. Pity's ways expressing extent when I storm out of an actual quarrel, I slam the door saying I pity you, I thereby inform what is beneath me. Describe things pitiful. Describe things not good for its kind. He is pitiful means he is arrested. The use of the word pity in a particular context seems to apply to speakers in some way better off than a person who's pity. Pity is self-regarding. If we have general duties to respect others, pity and sense are violations of the moral goodness of an instance is due to a desire to pursue another's well-being. The help rendered out of pity is not morally good if enhancing one's feelings of self-esteem is worthwhile. Boosting them out of pity for others leads to false feelings of self-esteem. If the feelings is smarted by associating with idiots, nothing changes that would warrant such enhanced feeling of pride. First, juvenile confidentiality demonstrates the desire of the court to protect juvenile from their mistakes. Blum writes. The movement towards maintaining juvenile confidentiality represents a split between what is perceived as good for the child and perceived good for the community. The aim of juvenile courts of preserving the confidentiality of juvenile records is hide youthful errors from the past gaze of the public and bury them in the graveyard of the forgotten past. The phrase youthful errors should never describe the murders, rapes, and other serious offenses that juveniles are not committing, the alarming violence that juveniles are committing today is forced. Communities demand that they be more concerned with protecting the lives and the safety of the public than what is protecting individual identities of the felon. Second, avoiding transferring juveniles to the adult system rests upon the cultural notion that juveniles ought to be pitied because they carry childlike characteristics. Bishop writes. The record shows that although judicial vote was available in nearly all states from the inception of juvenile court, it was used very rarely. Sparing use of transfers consistent with the principles of juvenile court, according to which juveniles differ from adults in ways that make criminal processing inappropriate and counterproductive. A fundamental tenet of the adolescent or immature intellectual capacity for reasoning and moral judgment to diminish their culpability and render them undeserving of the full burden of retributive punishment. Cultural conception of childhood and adolescence have traditionally emphasized use, dependency, and vulnerability characteristics that tend to evoke compassionate response rather than punitive ones. Third, the very creation of the juvenile court presumes a difference with juveniles that makes them akin to neglected children. Jordan Titus writes, children are perceived as needing protection from the consequences of their immaturity rather than accountable for the actual law proceedings. The child is sensitive creation in the juvenile court, reflecting the presumed essential difference between the moral and cognitive capacities of juvenile children were considered incapable of criminal justice. They were incapable of understanding the consequences of the actions of the parents repatriate. Jurisdiction of the juvenile court was designed to socialize delinquent youth into moral citizens. Children were perceived as both vulnerable and in need of adult protection. Then, as opposed to unsocialized the character of the neglected child, the delinquent child were deemed to like crime and destitution, were seen as indulgent linked to notions of childhood deprivation, became fused with notions of childhood. Fourth, the juvenile justice system was created out of belief that children ought to be pitted into their emotional state. Bloom writes, philosophers like Rousseau began arguing childhood disappeared in life and separate distinct from adulthood. Rousseau insisted that imposing an adult standard on children not only unnatural but also supports the child's development. Although Rousseau laid the foundation of the U.S. and not recognized these ideas until the latter part of the 19th century. At the time, G. Stanley Hall and other psychologists began to argue that children were not monsters that thought not that, nor were they responsible for their behavior until they passed through teenage years. Hall's theory provided a buffer between childhood and responsibility, describing adolescence and periods of storm sets from which one emerges mature and civilized. The youth who undergo wrong in the vast majority of cases, victims of circumstances or immaturity and deserving of pity, which earlier forms used to extend the age of criminal responsibility beyond traditional ages of 7, 10, and into the mid-teens. Thus, I affirm.
So, Titus and Bloom too says that the juvenile court treats juveniles as if they're like mentally incompetent or like their mental capacities are reduced, right?
It talks about how children are seen as needing protection and accountability is what Titus says.
Okay, where does it say that in Titus? Can you read me from the card when it says that?
Yeah. Children are perceived as needing protection from the consequence of their immaturity rather than as accountable for the action.
Right. It says that they need protection because they're immature. Why does that indicate that we're pitying them?
Because it says, we need to protect you because, oh, it's not your fault. Like, that's the definition of pity.
Really?
Yeah.
Why? Where do you define pity in the AC?
I mean, the conception that Nietzsche talks about in terms of the pity, Nietzsche talks about in terms of pity is when you like.
Isn't the Nietzschean conception of pity just like you see someone suffering, you feel like some sort of inclination to help them?
No, when you actually that's
actually okay. That's fine. Let's talk about the aft burden. What's the aft burden?
The affirmative burden is
at the top.
Oh yeah, that says that I can prove that the adult court's better than the juvenile court.
Okay, that's fine. So does that mean that you have to defend punishments of the adult system?
I'll defend punishment if you want me to.
Okay, cool. Now let's go to the argument about desirability, or like motivational, whatever the meta ethic is. So this argument says that you have to have desires, or else you have no inclination to follow an action, right?
What it says that you need to connect it back to the particular agent because things like reason can't guide our action.
So what can guide our action?
The individual's own choices of what they want to do.
So,
of what is in their best interest.
Why would it ever be in someone's best interest to restrict, like why is it in someone's best interest not to pity someone?
That's like all the cards explaining why pity is bad.
That's like Nietzsche?
That's Nietzsche 3.
Okay, the A and B arguments under that were just, how are they distinct? Don't they just say we can always question why we have this obligation?
What? They say we can question obligations from reason. We can't question obligations.
But so how are the A and B arguments distinct?
Sure, the A talks about how, for any moral principle, we can talk about why it binds we can ask why it binds cogently, showing that it has no influence on your will.
That's fine. Why is permissibility irrelevant in this circumstance?
The argument that I give for why permissibility is irrelevant is because, insofar as the reason why permissibility is irrelevant is because the person, we can't say that for a person who's acting in their self-interest, that something is a permissible statement for them, because that makes no sense to hold them by, like, those particular codified norms.
Okay, so do I have a moral obligation to drink water?
What?
Do I have a moral obligation to drink water?
According to this framework, if it would be, not under this framework, because it doesn't function under your like.
Finally, Nietzsche. What does Nietzsche 1 and Nietzsche 2 and Nietzsche 3 say?
Nietzsche 1 talks about how the utility of action was the word good, it hasn't been forgotten, but instead has moved itself into our consciousness as a means for the decision, the word useful. And then Nietzsche 3.
So that's just a spike to util, right?
No, not at all.
How does that justify your standard?
Sure, that talks about how the word good and the use for like us making ethical evaluations comes in the first place from us saying, like using it in terms in this manner, and it has just evolved lately into being used as like it's an unegoistic action, but that's not the origin of the word good and what's valuable.
All right, and Nietzsche 2?
Nietzsche 2 says that people praised unegoistic actions and labeled them as good, which means that it wasn't given due to their particular actions. Instead, it was established by good people who established it in opposition to things that were like low and vulgar.
All right, that's fine. And Nietzsche 3?
Nietzsche 3 says that pity is injurious to the health because it depends not on value but emotions, and there's nothing allowable or morally indifferent because you want, because you allow. The argument is that you allow yourself to be like controlled by your emotions, which is bad because then you can't do what's best for yourself.
Okay, that's fine. I do think it'll be an off case. It's going to be an off case.
Can we have two shakes? Probably back there is unplugged in, so
Okay.
I don't think.
I mean,
I think it's not on the cards at this lamp. It's gonna be.
it's not big.
Yeah. Can you grab this and hold?
I just noticed it was really dark. Okay. Is that ready?
Little sports center might brighten up too.
NC off AC.
Yeah.
Okay.
There's a reason God put a big screen TV in this room.
Thank you. These are front lines, so I'm not going to give you these. Audit is defined as expressing duty or obligation, proving that there is no more obligation to juvenile adults sufficient to negate physiological contact having an obligation given an action, not to have an obligation with that action, which includes having the choice character given action, not more words or connections with the common use of statement, I'm obligated to ice cream rather than chocolate ice cream, is disproved by package or that improved to other option because adult justice is retributive, whereas juvenile justice is rehabilitative in nature, negated from reality is unclear, as retributive relies on the ability to place blame on an individual to require specific conception of rights over affirming being impossible. Moreover, insofar as meta-ethical theory says that it's divorced from obligation, not as defined as obligation, that you prefer my definition because if he doesn't give it the AC, it's the next prerogative to define it in one end. Then, to attribute moral qualities to an action requires to be able to render moral statements objectively true. However, our inability to judge action without changing our evaluation of limited experiences makes it impossible to arrive at objective conclusions. Indeed, our limited capacity to experience perspectives of others prevents us from making true claims about morality. Nietzsche writes, the fallacy of judgment derives from any condition with the material to be judged, namely varying belief in the way that some has arrived at the basis of material, the fact that every individual piece of material is the outcome of false knowledge, and so with absolute necessity, our experience with another person, no matter how close he stands to us, can never be complete, so they never have a logical right to evaluation. All other evaluation of premature and bound to be the standard by which we measure human being is subject to moods and fluctuations. Yet we'd have to know ourselves fixed, so assess the relation between ourselves and anything else. Thus, objective moral claims can't be true as no objective evaluations which transcend different perspectives between people. Moreover, our own changing perspectives render all objective moral statements false, since we can only judge actions in relation to ourselves. Our own moral statements fluctuate, that these assessments can't be judgments that are constantly changing. Absent moral absolutism, the only way for us to create an odd statement to be logically consistent to follow contracts is they create stable rules. For example, you can always question what it means to treat someone as an end, but there's only one way to follow a contract, not to murder innocent people. Moreover, because our limited perception prevents us from making objective moral claims, the only way to make an odd statement is to be including as many perspectives as possible in moral evaluation. Hudgens writes, striving for the omniperspectival knowledge is the only logical way to even approach the inconceivable non-perspectival position. The omniperspective, as the name implies, would include the information available from all perspectives. The more perspectives we enjoy, for example, the more interest we will employ knowing the object, the better our conception of what the object will be like. Given that trying to reach the omniperspective can serve as the goal of plurality claim is subsumable only the omniperspectivity claim as part of the spectrum of truth. Since the incorporation of more perspectives makes statements resemble objective facts, we look to international law to generate moral obligations which are precluded by the skeptical conclusion of perspectivism. Thus, the negative words prove that treating juveniles adults violates law. First, the United States currently sentences juveniles life without parole. Candida Vega 1 writes, with thousands of juveniles serving LWP sentences and non-serving sentences in the rest of the world, the United States is not the only country violating this standard. 44 states and federal government allow LWP imposed on juvenile offenders. Sentencing to juveniles life without parole by the ICPR. Baby 2 continues. The United States ratified the ICPR in 1992. The extraordinary development of the United States sentencing child offense LWPs. The United States ratification of the ICPR contradicts the assertion the United States has only sentenced in exceptional circumstances. Total number of children tried as adults sentenced to LWP exceeds 2,484 million who were first-time offenders. Moreover, just Coach International Law prohibits LWP for juveniles. Baby 3 concludes. The prohibition against sentencing child offense LWP shall level the just Coach normal to rule of customary international law established that rules generally applies to all nations, including those who have not formally ratified it. Moreover, the United States law recognizes that customary international law as part of domestic United States law binds the government of the United States prohibition of LWP fulfills its requisites for 3 reasons. 1, there is widespread and consistent practice by countries not to impose a sentence of LWP for child offenders as a measure that is fundamental to basic human value, protecting the child. To the imposition of such sentences is relatively new and not practiced by only one nation, the United States. All of the states have taken up the practice of joining the global community, abolishing the sentence in 3 years, virtually universal acceptance the norms legally bound as codified by the CIC. And the affirmative maintains a prohibition. We can never institute moral obligations not time specific, because that is inconsistent along society's formulate their own ethical codes, because the affirmative defense of prohibition on juvenile justice regardless of context to negate. There must be an active distinction for 3 reasons. 1, ethics would otherwise fail us and we be held morally culpable every time we did an act something bad happens. No action would be morally permissible as the overwhelming impermissibility of an action outweighs the goodness of an action. 2, the active mission distinction preserves moral culpability, which is key to ethical reasoning, otherwise ethics couldn't guide actions. 3, without an active mission distinction, we have an infinite amount of positive obligations because we are responsible for any harmful outcome. Having infinite positive obligations paralyzed action, we can never fulfill our moral duties, therefore there must be an active mission distinction preserve morality is normative force. This is also going to directly apply to Dynas' standard because his standard is about like trying to judge actions, judging them pitiful, but if you're not actually judging an action as pitiful, then that means that you are omitting an action, can't be held responsible for that. Then negating an omission because 1, status quo is permissible to juveniles and adults. It's a negative attitude doesn't require deviation. The status quo, I don't have to take any action, so negating is an omission. And 2, the resolution phrases an action via the word treatment, since I don't have to defend an alternative treatment, my advocacy constitutes an omission. That's for the AC. Okay. On the top where he talks about the AFNEG burdens, he said they defend the adult justice system, so we're going to be linking into the NC. Don't let them de-link because the AS system currently sentences juveniles life without parole, the next system doesn't. Then, on the registrar analysis. One, I would say that if you call for the registrar analysis at the end of the round, it directly says that an action X has to be a desirable by an agent. This means that his ethics will ultimately devolve into like some sort of desirability calculus. But this is bad metaphysical theory because it leads to nihilism so far as it'd be in every agent's desire to reject any sort of ethical code because they know that would restrict their actions to some degree. So they would just want to preserve as many actions as humanly possible. Two, he can't defend a negative existential claim that it will never be in a person's desire to pity someone. So insofar as this is true, there's always a risk that it's going to be necessary to pity, it's going to be in our own desires. It's going to be motivational for us to pity someone. At which point that's going to be terminal defense on the NC. Three, I can be the standard because the A and B under his meta standards say that we can always question why we have an obligation. Remember my argument that the first argument for why contracts overcome skepticism is because we can always question moral theories. We have objective reasons to follow international law. Three, his arguments about desirability. If his argument truly about desirability, now just indicates you should negate because Shamus concludes that juvenile justice deterrence works without the conclusion that juvenile justice is better for recidivism. For this evidence, because specific to violent offenders, Shamus writes, juvenile incarceration recidivism behaviors use sentenced to state incarceration for 15 to 36 weeks has a daily hazard rate of recidivism that is approximately 37% lower than that of use. This contradicts the assertion of juvenile courts are ineffective at combating crime made by the actions against the attitude to the juvenile crime. That means that it is in everyone's desire, so that because no one actually wants to be killed, so insofar as that is true, we would just want to decrease recidivism as much as possible. So that's independent recidivism gate. And then five, I would say it's not a meta-ethical theory because this is only saying that certain ethical theories fail, but it doesn't tell us what is the warrant for an ethical theory. So if anything, it's just like some sort of like pre-standards argument, but it's certainly not a meta-ethical theory. Then the permissibility argument. His permissibility argument makes absolutely no sense because I asked in cross-examination certain actions be permissible. For example, me drinking water, he said yes, that argument is permissible. So this is really problematic for him presenting that there has to be permissibility. What's more, his standard doesn't include the notion of permissibility. For example, an act commission distinction would tell us that certain actions are permissible, and insofar as his argument is about pitying, if an action is not conducive to pitying or you're not pitying someone, but you're either taking either action or skepticism is true, then that means that every action is permissible. So that just means that permissibility is not true in the case of there's two mutual violations, but permissibility would still be true on skepticism. Finally, on Nietzsche. His Nietzsche 1 card is not a standard justification because his Nietzsche 1 card does not. His Nietzsche 1 card only explain why the word util has evolved to mean good. That has nothing to do with pity. Then his Nietzsche 2 argument is odd fallacy. You overviewed Nietzsche 1 and Nietzsche 2. These are both odd fallacies because he's talking about why in the status quo pity is based on is a moral parasite, but he's not explaining why that means that pity ought to be a moral parasite. Then on Nietzsche 3, one I'd say that the notion of having emotions and a reason to reject emotions is going to be disconnecting him from his standard because emotions guide our desires. If this is true, then that means that we can never fully enforce our emotions without delinking the meta-ethical theory. And finally, there's no warrant in Nietzsche 3. Nietzsche's just making an assertion. Then on the standard itself. One, it's not normative because it's only based on desires, so that means it can't generate an obligation. Two, it's not sufficiently explains why this is key for morality. It doesn't explain why we have the moral obligation to avoid pitying. Three, it's that procedural harms that if an act would rather have pity and whatever result in it, it would tell us we can't act as problematic for a standard. For example, if we have the adult system, we're going to be pitying the people who are in the adult system because the juvenile system are going to be pitying them. Finally, the juvenile system is retributive. Bazemore concludes. One attempt to bring rationality to rapid decision-making juvenile court stations to the application of justice falls. Retribution for reforms in various states led to increased incarceration. So that means that it's not pitying anymore, it's based on retribution.
Any of you mind if I sit down? Cool. What happens if we both agree we violate a contract?
Well, then one of two things would be true. We would have to weigh the relative contracts against each other.
How does your standard work? Like, how do we say, oh, like, this, it could work in two possible ways? How does your standard work?
Well, I'm saying that
is the question.
All right, I'll explain this. Either we can weigh the contracts, and if the contracts can't be weighed, then that means that contracts are not strong enough to
explain to me how the standard works. I'm
Do
asking
you want me to answer your question?
You're saying it can either be interpreted in two different ways.
Let me
one or the other.
No. Let me explain why these ways are not inconsistent with each other.
Okay.
So either we can compare the two contracts, or if the contracts are incomparable, then that means that clearly contracts are not powerful enough to overcome skepticism, and skepticism is true.
Wait, how do we compare contracts?
I don't know. You have to do that comparison, Dimas. I'm not going to do that work for you.
Wait, implicit in your... So you won't tell me how the standard gives us the ability to weigh back the possibility of the contract.
Dimas,
can you explain
you have to make
weigh back the possibility for contracts to your standard? Your standard says that international law is the basis of escaping this particular ability of skepticism. Where do you explain that that means that if we have
honestly,
more skepticism
in general, I would say that there's two mutual contracts that we would devolve to skepticism, which means that is not your turn ground.
Okay.
Your turn ground, however, would say that there's no violation of one contract.
Let's talk about the Nietzsche card you read.
That's fine.
Are we just going to ignore the third part of the genealogy of the metaphysics of, or the genealogy of that Nietzsche writes, which says that, like, this argument that says that the way to escape from this argument is the affirmative, in which we make value judgments based on whether or not it allows individuals to escape their emotion?
Wait a minute. I'm not exactly sure what you're referring to, so I'm gonna say.
What is your
no.
Nietzsche? What are you saying your Nietzsche argument says? What is your
My Nietzsche argument explains why moral judgments are necessarily gonna be inconclusive, which triggers Scout.
Why?
Because we can never judge an action as morally right or wrong.
The affirmative says that the way we do that is we reevaluate and has Nietzsche cards explaining why that's true. Why is your argument relevant then?
I don't know. Nietzsche was a syphilitic freak. Like, maybe he made multiple contradictory positions. You would have to explain why your Nietzsche cards would indict my Nietzsche cards.
Let's talk about this omission argument.
Yeah.
I'm debating in the status quo. Why does that mean debating is an omission?
First off, you don't make that argument in the AC.
Wait, you made the arguments about acts and omissions on this off.
Right.
Right. Why can't I respond to it?
What do you mean? You can make those arguments in the 1A.
Sure. My question is, I'm debating in the status quo, right? Your argument is the juvenile system is the status quo. Why is debating an omission?
No, your advocacy has to be treated the same as juveniles. Currently, we don't treat adults the same as juveniles.
Right, they are treated in a different system. Why is that an omission? Something happens in the status quo, right? Why does that mean it's an omission?
It's an omission because I don't have to deviate from the current system.
How does that make any sense?
Do you want me to explain the argument, Diamond?
Like, you still have to make an action. You still have an action happening in the status quo.
That's
right?
not true. And this status, an act omission distinction talks
Okay.
about our moral culpability for either affirming or negating the
That's
resolution.
fine.
And when you affirm, you're changing the you're changing what's going on currently. When you negate, you don't.
Okay. You off.
Oh damn. Okay.
Oh, God.
What's the nature of the outcase argument?
Here.
Three theory.
So it doesn't matter that I just finished like separating these all into really cleanly organized cells.
We might. It's possible we don't get to the last one, but we'll see.
All right. So,
Yeah.
so give me a second to finish.
1, 2, 2, 3.
Are we ready?
No.
Okay.
All right. Bring it up.
Are we ready?
Actually, still no. I just realized something. I didn't realize there's an egg right in the off case. I don't have that many off case sheets.
Will you hand me sheets, Dimus?
Of course.
Thanks.
All right. Now.
Alright. Ready? A is the interpretation on the January-February 2010 topic. Debaters may not make multiple arguments that one by one debater sufficient for them to win, but when linked by the other insufficient to justify about the other way. B is the violation. He makes lots of arguments that he can win in the round. Like the omissions argument is the first one. The second is the argument he's making on the affirmative case in terms of why the affirmative devolves to skepticism. The third is in the NC argument, which says that we can trigger talks about the triggering of skepticism. C stands for reciprocity. I have to answer the burden and win offense, while they only have to win burden or offense, thus imposing a much harder burden on me than on them. Circle burden is the only way to maintain a fair debate. Otherwise, one side's more likely to win. If that only is true, one burden fails, and the other is to be multiple burdens. Abuse is by the ability negative to run multiple necessary but insufficient burdens because each additional burden is another burden in which way only my opponent can win seconds to rescue. I can spend a lot of time in necessary burden with a lot of responsive returns, but he can just say that all I've done is not meet a not sufficient burden. This makes it no excuse for the negative because they have no way to lose the argument. There's opponent with the argument. This takes my time away so that I can make other arguments, but even if I win this argument to handle that, I still don't want the debate. The amount of time we are able to spend on each argument of our ability to attack and defend them when one debater makes more time than the other. That debaters are our ability to make more and better answers. This abuse is magnified by the already difficult one error constraints such as speech time. This abuse is empirically verified, hence endorse still right. Debaters who once are trying to have lost that round on the affirmative were more much likely to have lost that round on the affirmative over 80% of the time. Debaters with 5 once occurred, 65% of lost while on the affirmative the advantage enjoyed by the negatives pervasive getting worse, disproportionately disadvantaging the most successful debaters. This abuse maximizing the topic in which the affirmative defense different rules of criminal justice himself there's almost always subject to claim to topicality and legitimate fiat, so the use of the potential negative fiat maximizes the potential abuse. This also explains why you look to the affirmative necessarily for theory in order to determine who is the better debater, because insofar as that shows that you're not necessarily the better debater if they were more likely to have that particular loss than third. Time skew. Finding necessary but insufficient burden the affirmative needs to split up time among multiple issues while negative collapse any of them rule around this. To give the negative 6 to however many burdens you run time to get them to spend all the time on the affirmative to have split up arguments with others to answer time is key to fairness because the time we can spend on each argument is gateway to the quality of arguments and quality of arguments we can make if the already time start 1 error 4 to split up time on multiple arguments they can't win most if not all of the possible arguments. This additionally means the negative access 6 minutes to answer the case while the athlete gets half the time to answer them in 10. The AC means you are half on theory to rectify the inherent abuse. If you do are negative theory that would disprove the theory can function as an RBI. That would mean they get you 1 out of the offense the judge the drug to give them leeway and fourth quality of ground. The quality of arguments that are necessary but insufficient are always infinitely higher for the negative because they are near infinite assumptions and aspects of the resolution that can be proved false while proving the truth of the statement can only be achieved by proving the truth of major or minor premise and thus deriving logically correct conclusion or by reducing the resolution to a single premise which is tautologically true. Both of those arguments, however, are preceded by potential negative criticism which you challenge the validity of existential premises, quality of graphically fairness has definitional ability to win out good arguments. Also, functions the offensive back to education, but debaters simply able to undermine these substantive premises. They can select the same arguments for topic for which resolutions assume common major or minor premises and occasionally even common minor premises such as the existence of moral specific moral obligation. Additionally, because they are running necessary but sufficient burden, they will be better prepared because they know the abuse story could appear and every round, thus making it infinitely more predictable for them. So the only bit of opposite is their alpha theory D voter. Fairness axiomatic principle can better act since equal chance win gives legitimacy to the victor. Otherwise, we flip going to decide the round or debate or ignore the debate. Fairness proceeds up to concerns the ability to contest argumentation stops parameters for sufficient substantive burdens. Additionally, you need fairness in order to determine who is the better debating because otherwise because we don't determine who's the better runner if one has albatross tied to his neck. Both the position down theories debate over competing interpretation. Thus, reasonability encourages intervention, adopting minimum standards of fairness. If they violate the better rule, they should lose around. Therefore, this is a positive burden for my vote to provide counter interpretation. Otherwise, they force judge intervention, which will always worse the debate is moreover proving. Additionally, voting on fairness is the only way to encourage good debate in the long run because otherwise debaters have incentive to run short abuse and strategies generates the time trade-off on theory of what debaters lose argument. It creates an incentive to run them. Thus, dropping the argument encourages bad debate. Dropping the debater encourages good debate. So then, second off. A is the interpretation standard cannot label either side to win absent net offense. B is the violation. D is the standard excludes the comparison of impacts. He says that offense on both sides means permissibility. That's what he says in terms of comparison of offense. There's literally no way to explain back to his particular standard that reason that I gave case what it would mean for us to vote, whether it would mean for a contrary to be more important because both trigger skepticism. C stands first reciprocity. A absent comparison of offense. One, the fact that both sides one offense against only a tie goes the negative against the negative of the ballot, even though both debaters run the same distance, this is non-reciprocal and therefore unfair. B is massively amplified in the world of the ab actually it's one time more offense than the negative but still loses because any offense is not said enough for permissibility. C additionally, in order to avoid the loss of the offense to win 100% defense, the risk of offense with the negative only has to win a risk of offense that you need to consider winning defense. You can cross by white reciprocity is important. Strategy. Second strategy way is key to firm strategy because times two structurally advantage negative to win a higher amount of quantity of arguments. The only way firmness can compensate is by weighing the quality of arguments you can cross by strategy is important from the other side.
Okay, before I start, can you just hand me your fairness voter?
Yeah. That's what I read.
Okay.
And then I made an additional argument.
Okay.
All that work and there's never a third off.
Hey, you're gonna have to signpost.
Well, I was listening to you.
Okay, yeah, just start on the NC. Okay. Alright, is everyone ready? Except permissibility, number one is that proving that there is no more obligation to do not thus sufficient to negate because logical concept having an obligation to commit an action, not to have an obligation to commit that act, which is inclusive of having the choice of character to give it an action or not. This means that he is losing in the theory debate where he's voting on permissibility because he doesn't extend any positive reason to affirm. Then, extend skepticism. We cannot objectively judge the moral qualities of an action. This is Nietzsche. No matter how close we stand in relation to someone or our experience with evaluations of them are incomplete because of our limited perceptions and our mood fluctuates, so we cannot objectively judge anything. This means I'm triggering skepticism because he doesn't answer the I law stuff. So I'm going to be kicking I law, I'm going to be triggering skepticism, so I'm doing permissibility on two levels. The first level is that he's not extending half offense, the second level is that I'm triggering skepticism. So, first cross application to his voter. His first argument for his voter says that theory is an axiomatic principle. This is really problematic because skepticism precludes the axiomatic principle. Insofar as skepticism says we can never judge in relation to an axiomatic principle. This is really problematic that he drops skepticism. Don't let him do any work on this in the next page because that would be functionally new in the two. Second, his second argument says that it's necessary to determine who's doing the better debating. First, the ballot, when you evaluate, first, I say this argument is instantly aggressive because it doesn't explain what it means, he doesn't objectively define what it means to be doing the better debating, and second, he's not explaining why I'm cheating, he's only explaining why I am like skewing fairness, I'm skewing like fairness to some degree. His argument about the albatross being tied to his neck explains why a runner's function that couldn't win the argument, he's not explaining why I'm like 100% preventing him from winning from like winning the debate, but what's more, I would say that the skepticism is also ending this argument because he says it's necessary for determining who is doing the better debater, but that's not true because you don't have any sort of moral obligation to determine who's doing the better debater. So your obligation is just to vote on who is doing, like whether or not you affirm or negate. Because remember, he is triggering, he is conceding that the sufficient negative burden is to prove permissibility. So that means that that's your only voter in the round. Because he tries to extend an argument about why you have a moral obligation to determine who's doing the better debate. Remember, skepticism precludes that. So that means that the only voting issue in the round is going to be permissibility. So that's the reason why we're doing something about permissibility. Really easy right there. Now let's go to the theory shelf. On the first shelf. on the intern. One, I mean, he could have run permissibility. I run permissibility function every single one of my ACs. That means that all the arguments he talks about the exact emission distinction, the skepticism, the skep triggers on the AC could all have been going at. All he has to do is run the permissibility debate, meaning that he has access to all these arguments. This so I mean his interpretation because these arguments are no longer necessary but sufficient. He has very clear turn ground on this argument. Don't let him say that permissibility is only negative ground because we always have to have a permissibility debate. Second, I mean again. In terms of specifically on the active emission distinction argument, he could have just argued why affirming is an omission, at which point that is turn ground for him on the I law. Remember, when he talks about the skepticism debate, remember I law is the way to get out of skepticism. He could have talked about why we did not sign an obligation to negate, but we did sign an obligation to affirm, and in terms of international contract. And finally, on skep triggers, remember, he could just place defense on skep triggers, and it's just like me indicting his framework. So there's no reason why I shouldn't have access to defense or that's necessary, but it's sufficient burden. So that means that's the second I mean. Third, I mean, he could have run as insufficient burdens in the 1AC. He chose not to. Don't blame me for strategic shortcomings. And then 4, he links into the shell himself because remember, one of the alpha arguments explains why he's not being normative. The reason he's not being normative is because his framework itself does not explain why we have a moral obligation to do something. He rather just says that if we don't do this, then morality functionally ceases to exist. This means that all of his arguments are necessary but insufficient because even if I wouldn't turn on it, it doesn't explain why you have a moral obligation to the game. Remember, this is because his framework is insufficient. So that means that all of the AC functions become necessary but insufficient insofar as his framework doesn't actually generate a moral obligation. So that means that he is linking the shell just as bad as I am. I'm winning 3 clear IPs and one of the violations, so you're not going to be voting on that shell. Then, on the second shell. The violation of the second shell is permissibility. Remember, I already gave a lot of reasons why he could have been winning permissibility. He could have talked about why we ought to presume that given permissibility, we look to retribution versus rehabilitation, for example. So that means that, or he could talk about like how if it were a permissible scenario, then ought no longer functions to operate as morality rather than natural consequence. However, he chose not to do this, meaning that I'm giving you 2 very clear ways that the affirmative could have triggered permissibility, and he chose not to, meaning that I'm giving him lots of turn ground. So permissibility is not a violation. Second, I mean it again because permissibility is offense. His interpretation says that I can't win I can't win if there's like no offense. Remember, permissibility is offense. So I use interpretation again. Then I mean it in a third way because we can compare act offense versus permissibility. For example, if he's winning a reason as to why Nietzsche says that we have a moral obligation to affirm, for example, but you compare that to permissibility, then obviously that argument comes first. Meaning that insofar as permissibility is offense, we still have the ability to compare relative offenses. So that means that I mean his interpretation in a third way. And then 4, actually that's it. So here's how the round's breaking down. It is extraordinarily clear. Biggest, most damning argument on the theory shell was the fact that he could have run permissibility. I gave you 2 very easy ways that he could have run permissibility, at which point he would have gotten access to all the arguments, and I'm mitigating 100% of the views. Finally, you're not going to be voting on theories of competing interpretation. Sorry, I should have not done this crystallization. This is going to be the reason why it's not an issue of competing interpretation. Counter-interpretation create a race to the bottom. Competing interpretation has no limit to how fair an argument should be. Therefore, some arguments are just enough fair, that argument is slightly fairer than the others, and that argument can be considered fair, and that reasonability play out standard goals is being fair, and 2 competing interpretation vastly preferences debate running theory because all they have to do is demonstrate a marginal abuse scenario. This could be said into debating one interpretation and indicate the most marginal matters in order to minimize room for contestation, reasonability checks back on necessary marginal theory arguments. This argument for why we look to competing interpretations is to prevent judge intervention. But I said the judge doesn't intervene anyway because we look to the standard and a theory shell as a way to prevent judge intervention because those are arguments the same way the operator criteria, meaning that we're looking to reasonability. So at the very least, I'm mitigating 100% of the abuse that's coming out of the theory shell. I have multiple line means. The fact that he could have run permissibility is going to be really, really damning on all the theory shells. And you're going to be voting permissibility neg. Very easy neg ballot.
Cool. I have 420 left. Let's talk about your arguments on the shell.
Mm-hmm.
So, you said I could have read permissibility too.
Mm-hmm.
How does that meet my interpretation?
Because
that says I could have violated my interpretation too. How does that prove you meet it?
So, the first shell, your argument says that I can't run multiple arguments which are necessary but insufficient. I'm meeting your shell by demonstrating why it's not necessary but insufficient. Wait. Permissibility makes the argument no longer necessary.
No, you said I could have run
insufficient.
permissibility too in the affirmative.
Right. So
that says I could have violated my interpretation too, insofar as that triggers.
Do you want me to explain?
What about the other arguments in terms of the skepticism arguments is my question.
Wait, the skepticism arguments in the first shell or the second shell?
The necessary but insufficient burdens shell.
Okay, so on necessary but insufficient burdens, the reason the reason you have access to skepticism is because you could have turned I law. So it's not necessary but insufficient.
Okay, you just extended in the last speech your Nietzsche argument when I conceded the I law arguments to say that triggers skepticism.
You should have conceded skepticism. You shouldn't have conceded skepticism and I law.
If I conceded I law is true.
If you conceded I law,
if I concede there's a violation, if I concede there's whatever particular violation of I law, how do I concede that the skepticism is true?
Wait, because you don't do work as to how I violate I law. So
Okay.
That means that I don't have to go for I law.
Okay, let's talk about the arguments you make to the second I meet argument. Or actually, yeah, the second I meet argument on. Or no, let's talk about your answers to the voter. Let's do that.
Okay.
Your argument says it precludes axiomatic principles.
Yeah.
What's the warrant?
Well, because the whole purpose of Nietzsche says that we can never have these kinds of objective principles. So that means that insofar as your argument is about theory
Nietzsche
being...
says there are subjective principles. Why does that exclude axiomatic ones?
No, Nietzsche says that there can't be objective judgments and there can't be objective principles. Therefore, we can't have axiomatic principles.
Wait,
so
what?
Sket precludes.
Say that again.
Okay, Nietzsche's argument says that there can't be objective principles, so that means that there can't be axiomatic principles either, because axiomatic principles are objective principles.
Why?
I mean, if you want to get into the semantic distinction,
Why?
you can go ahead and do that. But an axiomatic principle is a principle like which applies in every single circumstance. That's like the exact same thing as what an objective principle is.
Okay, why is the reason that, what is the specific reason why Nietzsche applies to why those axiomatic principles wouldn't exist in terms of fairness?
Well, because any axiomatic principle couldn't exist.
Okay, let's talk about your arguments. Okay, your argument says it's infinitely regressive because I don't define who does the better debating.
Yeah, there's no objective way to determine who does the objective debate, who does the better debating, and there's no moral obligation to define who's doing the better debating. So you just sign your ballot nay.
Okay. Do you give in the last speech a bright line for what is permissible? Or not permissible? What is reasonable? You read the reasonability arguments. Do you give a reason what the threshold for reasonability is? Because your argument says there's no intervention. We can judge when it's reasonable. Do you give a bright line for that?
Well, if you're demonstrating clear abuse, like this argument is just a.
If I demonstrate clear abuse, I win.
Well, no. This is just an indict to you being like, oh, no counterinterp, you lose.
Oh, if I don't provide a counterinterpretation. So you still have to, in terms of the offense to the arguments.
No, this is not an argument that's saying, judges, don't look at the theory. This is an argument that's preempting you from saying, reject all the defense on theory because he did not read a counterinterp.
Sure, I'm not going to run notes.
People do that all the time.
But you're not claiming that there should be a different threshold for what we determine in terms of...
No, I mean, you still look to the standards in the same way you look to like, a criterion.
Standards, great. Okay. That's fine. You can have that theories. I handed you stuff.
What did you want?
I handed you, like, the shell. My
I
shell.
don't think you gave me anything. Wait, I'll look through it.
Did I not?
I don't think so.
Oh, okay, I got it. Never mind. Okay. Overview to the round, voter stuff. Then I'll signpost from there, but it'll probably be the permissibility shell, and then the other one.
Wait, necessary but insufficient burden. The first shell, the second shell.
The voter is the first. So you go the voter follow with necessary but insufficient burden stuff.
Okay.
Since that was the first shell. Okay. So it'll start in necessary but insufficient burden shell. Everyone ready? The biggest problem Nate makes in the rounds is conceiving a lot of arguments in the interpretation that I give for why you should err half on theory. You can extend the Henson-Dorsal analysis, which says that debaters were much more likely to lose on the affirmative than were the negative, so we needed this in order to judge those particularities. I'd say the way you err half on theory is not allowing you to cross-apply substantive arguments in order to theoretical arguments. He gives no reason why those arguments can mix, so I'd say if I give you reasons why the substantive arguments can't necessarily mix with theoretical arguments, you prefer those arguments, but I'm actually telling you why they can function. So first, I'd say that I'd say you can extend the argument from that I make in the original show was that fairness necessarily has to precede substantive concerns in the first place, because so far as we have to proceed substantive concerns, because so far as we have to judge what's fair in the first place and make those particular determinations, then substance necessarily comes out of that. But then second, I'd say there's a distinction between in-round and out-of-round argumentation. I am providing that there's like something about international contracts. This doesn't mean that for you an individual as a judge or you fulfilling your particular role necessarily means that skepticism argument doesn't exist. So at very least I'd say you prefer doesn't necessarily mean that for you as the judge it doesn't exist in that particular manner as your like job in order to be the adjudicator of the debate round. But then third, I'd say at very least there's going to be a risk of possible offense in theory. So I'd say if there's going to be a risk of offense in order to the voter, and it comes for he's conceding that it comes first, it's going to matter. So you can extend the argument that it's an axiomatic principle of better activities. Otherwise, we'd flip one in order to decide who the winner of the debate round was. Then he's not. So then we can go to the permissibility shell. His first argument against is that we could have said look at permissibility too. I'm indicting the function of the standard that says in terms of whether or not you could. I'm indicting the function of the standard that says we default to permissibility if there are two violations on both sides. Not saying that I can't run permissibility ground. The second argument says he meets because it is offense. My argument is that there's no net offense because the comparison is literally nonsensical with regards to a standard. It makes no sense to make a comparison in terms of the Nietzsche argument because it says any violation of the international law agreements doesn't work. The third argument is that we compare the affirmative to the negative. That doesn't answer his argument. His standard still functions in this manner. He's conceding that his standard functions in that manner. So you can extend the interpretation. You can extend my interpretation, which says the standard cannot enable either side to win absent net offense. B is the violation. Insofar as he says that he can't. Insofar as there's no net offense when there are two particular violations, then there's no way that we can compare between those via given his standard. You can extend reciprocity, which says that absent comparison of offense, one fact, both sides, one offense gets its only tie. Tie goes negative is negative value. Though both debaters are running at the same distance, this is non-reciprocal and therefore unfair. He's conceding that argument directly. Then go to the necessary evidence sufficient burden to show. Go to his first argument that he could have run 2. This proves that could have run on necessary but insufficient burdens 2. This does not respond to my interpretation. This just proves that I could have violated 2, but doesn't prove that it's proactively bad. The second argument says that I can win with an active, I could have won with omission, but no, I can't because he can turn his arguments on the AC, so directly trigger skepticism too. He has arguments on the affirmative that he says always trigger skepticism. The third argument is that I could have run them too. You can cross-apply the argument from the first response, which is that this is not sufficient in order to give me that ground. I'm still showing you other necessary but insufficient burdens that he's violating with the arguments he's making on the affirmative. The fourth argument is that it links to the framework because my framework says no moral obligation, but no. Because I said you can prove that in terms of pity, that there's more pity, and that's necessarily a comparison. But also, you are going to be ignoring all his argument to the extension of the fourth standard. You can extend the fourth standard with quality of ground. It says negative necessary but insufficient burdens are always better because there's nearly an infinite number of minor premises and major premises that he can disprove, which means that this argument is going to be irrelevant because regardless, skepticism always comes first, and that always has to negate.
Good round, Dennis.